Okay, we are ready to start our afternoon program. Thank you all for staying with us. I hope you enjoyed a very tasty lunch, and we are energized and ready for some more fantastic speakers. So our program, as many of you know, for the afternoon, we are now gearing up for our keynote lecture, and I'll be introducing our keynote speaker momentarily. And then we will transition directly into the Grodzki Prize award ceremony. And then we'll have our two panels, panels 3 and 4. And then we will have a reception at 5:30 right here in the FCC. So we'll be spending a fair amount of time together here for the remainder of the day. And thank you for being here. So again, my name is Randall Abaid. I'm the Assistant Dean for Environmental Law Studies. And it's my distinct honor and pleasure to introduce our keynote speaker for today, Professor Jim Anaya. And he has a very impressive bio in our program, so I'm not going to read that. I thought it might be helpful to highlight someone as someone who's been in adjacent fields for a fair amount of my career, just to give you a sense of the honor it is for me to be able to introduce someone like Professor Anaya. There's certainly something I found challenging in my career, which is wearing many hats. The people I really respect in life are those who are really good at lots of things. I'm not one of those. So in this role where I've had to be dean and teacher and scholar and mentor and fundraiser and everything else, balls fall every day that I try to do all of that. Not so for Professor Anaya. Professor Anaya has been the dean of University of Colorado Law School for several years and is now back to full-time professor life. But what really is most impressive to me is the impact he's had on the field that he has been a scholar in for so many years. So I was teaching human rights and environmental protection back in, I guess I started that probably around 2008. So I was pretty far into my career as an academic, and I was teaching cases that were so inspiring to me that they were groundbreaking. They really defined why we have a field known as human rights and environmental protection. And I learned very recently that one of the cases that I talked about quite regularly, the Awas Tingni case, was thanks to the gentleman next to me, that very, very early in the process of the evolution of the field of human rights and environmental protection, Professor Anaya was in the trenches, so to speak, creating that, being instrumental in creating that jurisprudence that we now all rely on as we seek to build on that in areas like what we're talking about today in this conference and areas like my space of climate justice and so forth. In addition to that, as someone who's taught climate change and indigenous peoples for many years, one piece of an international legal instrument that means a lot to me and I feel has been very impactful is the UN Declaration on the Rights of Indigenous People. And for those of you students who are not familiar with international law, patience is the first thing you need to have. So this is a declaration, a non-binding instrument that took a decade to negotiate. And again, Professor Anaya was instrumental in contributing to what ultimately became that success that we now appreciate as UNDRIP, the UN Declaration on the Rights of Indigenous Peoples. And because of the way international law works, even though it's non-binding, it has been tremendously influential as the field continues to evolve in the protection of rights of indigenous peoples and how that intersects with human rights and environmental protection issues. So that's been another focus area of my scholarship that I'm very grateful that we can have someone who is so instrumental in making that happen with us today. And also as someone who has intersected with international law, public international law more generally. We have happy to have Dean Solorio, Dean Rosa Solorio with us, who is the Dean of our International and Comparative Law program, much more invested and experienced in that space than I am. But every time I did any kind of public international law research and writing, I came across the name James Anaya. It was inevitable. It's cited in many of my writings. It was everywhere I looked. And certainly as one who studied also indigenous peoples protections, once again, absolutely a leader domestically and internationally on these very important issues that mean so much when we think about advancing, moving the ball forward on human rights and environmental protection and rights of Indigenous peoples. So I'm happy that I've been able to add a course to our curriculum on Indigenous rights and environmental protection. Would love to have Professor Anaya as a guest speaker in that class one day. It's taught by Professor Upasana Khatri, who's in the audience, and she'll be speaking on our fourth panel today. So I could go on and on, but I shouldn't because we're behind schedule. So with all of that, it is my delight to introduce Professor Jim Anaya to you for our keynote lecture.
Thank you. So, am I on? Am I on? Do I need to be? Can you hear me okay? Yeah, thank you for that very kind introduction, Randall, and thank you so much, and to all the organizers for including me in this really tremendous, informative, and thought-provoking symposium. This is my first time in this room. GW has, as you know, those of you who have been here before, has a rich array of activities having to do with international law, international human rights. And in fact, two of my co-authors on my international human rights casebook are from GW, Dean Rosa Solorio. It's great to see you. We spent a lot of time on Zoom, and nice to be in person. And of course, Diana Shelton, who's now retired. So it's wonderful to be here, in a sense, a place I'm familiar with, and it's great to be exposed now to the environmental law program through this symposium. The theme of this symposium leads us to examine the relationship between foreign investment, investment treaties, and the human rights and environmental health of Indigenous peoples and other communities. For those of us interested in this theme, we're drawn to different sets of inquiries and lines of thought, as we've seen illustrated in the symposium this morning. Now, I'd like to start my remarks by identifying and synthesizing what I see as three of these lines of thought. A first one involves pondering the frequent negative and sometimes devastating effects of transnational investment activities, especially those involving large-scale development projects on Indigenous or other communities that are within or near the physical footprints of the projects. Contamination of water sources, degradation of soils and subsistence resources, deforestation, child labor, acts of violence against women and others. These are all too familiar examples of some of the unfortunate byproducts of projects backed by substantial flows of capital. These and other multiple scenarios represent affronts on human rights, including the right to life, physical security, a healthy environment, and in some cases involving Indigenous peoples, the rights to their traditional lands and natural resources and their right to self-determination. A second line of thought centers on the frequent tension, and we heard a good bit about this morning, or incongruity between, on the one hand, aspects of international investment law, and on the other, international human rights law or international environmental law. The degree of this tension, in my observation, is in part a function of the way the content of these different international legal regimes are interpreted and applied. And so as we can see in a number of investment arbitration awards, the tension is more or less acute, depending on the interpretation of investment treaties in connection with their capacity to accommodate human rights or social values, or depending on interpretation of the content of human rights that might be involved, such as the right to a clean and healthy environment, the content of which remains evolving and somewhat contested. So take, for example, an investment dispute concerning a mining operation and implicating the human right to water or to a clean and healthy environment. If the relevant investment treaty is seen as less accommodating to human rights and social values, it will be it will be seen as more in tension with the applicable human rights norms, the more far-reaching those norms are said to be. So identifying the degree of tension between these different legal and normative regimes through interpretation of the context is part of this second line of thought focused on the tension among these regimes. Now, a third line of thought and inquiry explores strategies for resolving this tension between international investment law and the other areas I mentioned of international law, human rights, and environmental law. For many of us, myself included, this line of thought tends towards strategies that would resolve this tension in favor of human rights and the environment. One strategy begins with highlighting the international law obligations of states to protect human rights, an obligation that's well established in international human rights law. And it encourages states to fulfill this obligation through their regulatory powers over investors and the projects that they advance. Now, this strategy has already achieved some success, for example, through the adoption in several countries of strong environmental legislation requiring companies to engage in human rights due diligence, and state mandatory consultation or consent procedures that engage potentially affected or affected stakeholders. Now, while favoring human rights in the environment, these strategies do not themselves resolve the tensions with treaties that liberally invite investment. And hence, a second strategy to resolving the tension is to press for international investment treaties that explicitly allow for these types of legislation or regulatory measures, and that have adequate carve-outs for state regulation in favor of social concerns. And as we heard about this morning, this strategy has yielded some success as well. And we can see this in a growing number in international investment treaties that with provisions that safeguard states' autonomy to regulate investments in order to advance public policy objectives, sometimes specifically concerning human rights and the environment. And yet another strategy to address this tension is to directly press investors and their companies to self-regulate. And now, especially animating the strategy today are the UN guiding principles on business and human rights, which I'm sure many of us in the room are familiar with. These are principles that were developed through the mechanisms of the Human Rights Council, the special procedures mechanisms by Special Representative on Business and Human Rights, John Ruggie, and principles were endorsed by the full Human Rights Council in 2011 and have become the major, I believe, instrument internationally or within the international human rights regime addressing that intersection between business and human rights. They affirm that business enterprises have an independent responsibility to respect human rights in all their operations and business relations. And in fact, we see that several major extractive companies and associations of mining and other extractive companies, including the International Council on Mining and Metals, whose membership includes the major mining companies, have pledged adherence to the UN guiding principles. The ICMM, International Council on Mining and Metals, has recently adopted a standard that transposes the guiding principles to the specific context of mining affecting indigenous peoples. And additionally, international mechanisms are being developed, such as those associated with the UN Working Group on Business and Human Rights, to directly hold companies to their responsibility to human rights, independently of what states may or may not require. Now, the record of actual compliance by companies with the guiding principles, unfortunately, is lacking, and there's a lot to talk about that. Nonetheless, these guiding principles are there. Now, all these lines of thinking and strategies that I referred to are all important. With them, we identify and can push back on the negative impacts of foreign investment, whether or not sanctioned by a treaty. We can push back on the negative impacts, particularly on human rights and environmental well-being, and including that of indigenous peoples and their communities, a theme that we've been touching upon today, and that's the theme, as I understand it, of the symposium. So, all those lines of thought and strategies are important. But for now, I want to put them aside. I want to now ponder, feel for me, the following, which is going a bit beyond perhaps the specific subject matter or theme of the conference, but it's nonetheless quite related, I believe. I want to ponder the following. Is it possible to do more than defend against the negative impacts of foreign investment on human rights and environmental well-being? Is it possible that foreign investment, again, whether or not sanctioned by an investment treaty, can be a positive vehicle for the realization of basic human values? So the answer, in my view, and this might come as a surprise to some, but nonetheless, the answer in my view, especially, is yes, especially with regard to the human right to development. Professor Harold Koh, whom many in the room know, has emphasized that free trade is not an end in itself. Rather, drawing from the preamble to the agreement establishing the World Trade Organization, he asserts that trade liberalization is, at its conception, part of a system related to the fulfillment of basic human values, including the improvement of living standards. Now, the global system of international investment agreements and practices can similarly be understood to be premised on this ideal, I believe, although both liberalized trade and the flow of capital have fallen short of that ideal. Now, I want to now offer some observations and thoughts with the hope of stimulating thinking about approaches to harnessing investment to advance human rights. To try to make my points along these lines most clearly, I'll focus on indigenous peoples in particular, because among them, we can already find investment activities that are illuminating in this connection. Additionally, established international standards both protect the specific rights of indigenous peoples and facilitate the possibility that they might take advantage of investment activities under the right circumstances, as I'll try to explain. So, for starters, let me take you back to the West, to Colorado, where I live, and think of the example of the Southern Ute tribe living there, whose Aboriginal territory is there. This tribe's lands are rich in oil and gas resources. In the 1960s, the U.S. Department of Interior began issuing private leases to private companies to drill for oil on the tribe's reservation land. Now, the tribe then was given paltry sums of money in royalties, and environmental damage that was caused by the oil and gas development went substantially unchecked. That was the situation with outside oil and gas investors taking the oil and gas from the tribe's lands under the supervision or presumed supervision of the United States federal government. But over time, Southern Ute tribe prevailed in its efforts to have those leases to the outside companies expire or even cancel. And with what can only be described as innovative and bold leadership, the tribe hired its own attorneys and industry consultants, and it eventually built its own oil and gas company. The tribe's company generated significant revenue that was put into an investment fund that the tribe also created. And now the tribe's company has joint ventures for the development of renewable and non-renewable resources in several parts of North America and in the Gulf of Mexico, Yes, the Gulf of Mexico. Um, the I know I'm in Washington, but nonetheless, it's still what we call it back west. So the tribe's members, once impoverished, now all, for the most part, it's fair to say, benefit from the tribe's collective wealth and the revenue streams that it has been able to create. And those are generally under careful management, I think it's fair to say. All the tribe's young people are guaranteed scholarships to attend college or university, and the tribe's centuries-old culture has been, in significant ways, reinvigorated by accounts of tribal members themselves, and including through language restoration programs. And so now in control of their own resource development, the Southern Ute tribe has been able to enhance environmental quality throughout its reservation and adjacent areas. Given where the Southern Ute tribe is today, it would be unthinkable for outside investors, foreign or other, to invest on its traditional lands without the tribe being in control. The tribe is now situated to initiate investment of its own or to partner with investors. And it's now apparent that as long as the tribe is in control, that investment can work to the tribe's advantage and to the advantage of its members. Compared to indigenous peoples in other countries, the Southern Ute tribe is admittedly in a privileged situation, in part because indigenous nations and the United States do have beneficial rights to the resources, including subsurface resources on their reservation lands. The point is, though, that the tribe is an indigenous people that can be open to investment opportunities, including from outside investors, if that investment is in keeping with the tribe's self-determination and is beneficial for the tribes and its members' development. The Southern Ute example is not alone. Other examples can be found in Canada, where there are instances of numerous First Nations building businesses and entering into joint ventures with outside investors, including foreign investors. And as the Canadian federal and provincial governments have become more hospitable and even supportive of these kinds of ventures, they appear to be on the rise. Now, most of these kinds of commercial investment activities in cooperation with indigenous peoples occur in developed countries, including, in addition to the United States, you can see them also in Australia and New Zealand. In these countries, many of these investment activities involve not just resource extraction, but also forestry, fisheries, and renewable energy projects. Even though mostly happening in developing countries, these experiences generally show that when indigenous peoples are in control of or involved as partners in investment projects in their territories, they stand to benefit from those projects. And environmental impacts are minimized, even where extractive industries are involved. As the ones closest to the projects, indigenous peoples naturally have a strong incentive to ensure adequate environmental protections. With the appropriate conditions, investment activity could likely benefit indigenous peoples beyond North America and other parts of the developed world. And that is already happening in a number of cases on the basis of consultation and consent procedures that have engaged indigenous peoples around specific investment projects in the developing world. Recently in Belize, for example, Maya communities entered into months-long consultation that led to a consent agreement with the government and a US-based company for oil exploration on their lands. The communities there had the foresight to seek out qualified counsel and that could help them explore their options and agree and arrive at an acceptable, agreed upon outcome. One that, upon examination, appears to be beneficial, actually, to the communities, or potentially so, at least into the future, even while they were able to maintain their subsistence way of life in their forest lands. So it's in this context that understanding of the international standard of free, prior, and informed consent, or FPIC, becomes especially relevant. And I know we're all fans of FPIC, right? It's a very much repeated acronym in the circles that many of us run in. This international standard of FPIC is found in several international instruments, as we know, and is referenced in decisions relating to investment or development projects involving indigenous peoples. In numerous decisions by international human rights bodies and in a few investment arbitration awards, the FPIC standard has been found to have been observed only in its breach. At the same time, in practice, FPIC appears to be most invoked by indigenous peoples in many parts of the world, by indigenous people and their advocates. It's been most invoked to stop investment projects. In this sense, FPIC is wielded as an attempted veto power, but one that in all too many instances turns out not to be so powerful. All too often overlooked is the consent side of free, prior, and informed consent. That is, the right indigenous peoples have to consent to investment projects affecting their lands and resources. The consent part of the FPIC standard and associated prescriptions provide the framework for potentially mutually beneficial investment projects on or near indigenous peoples' territories. It follows from the human rights grounding of the FPIC standard that consent must be based on terms that are just and that in the end are protective of and advance the exercise of indigenous peoples' rights. So, as indicated by a number of international decisions, indigenous peoples' consent should be by mutual agreement based on just terms and not merely on any terms or no terms at all. These international sources, numerous ones, indicate that the terms of consent should include, at a minimum, measures to mitigate against environmental harm, compensation for adverse effects of a project, and sharing in economic benefits to be derived from the project. And of course, it stands for indigenous peoples to decide whether an investment project with those kinds of terms fits in their own development and related aspirations. Typically, especially in the developing world, indigenous peoples have not been accorded that choice to freely choose or not to choose to accept investment projects on their lands. Investment projects affecting indigenous peoples usually have been designed without seeing them as genuine partners, and their consent has been seen as an obstacle to overcome. So faced with such scenarios, naturally, indigenous peoples and their advocates gravitate to the no consent side of FPIC. And with no indigenous consent in the face of projects that are thrust upon them, as we've seen in many instances, conflict arises or the absence of social license leads to instability in projects. Projects based on fair and just agreements with indigenous peoples who are affected by the projects will not just be more stable, they can, if done correctly, advance the human right to development and other human rights. So my proposal is foremost and first to not bypass the possibility that indigenous peoples or other communities can benefit from investment activities or that they can be partners with investors. Rather, in my view, more attention should be advanced toward a shift beyond a paradigm in which foreign investment is only pressed not to do harm to indigenous peoples or others' human rights and environmental well-being. There should also be a focus on investments as a possible conduit for the enjoyment of human rights of those who are closest to the investment activities. So to that end, there should be a close attention to the conditions that are required to be in place for this kind of investor community partnership to successfully happen. And turning again and emphasizing the specific situations of Indigenous peoples, let me end by summarizing what I see to be the minimum conditions. First, there needs to be adequate domestic legislative and regulatory frameworks that recognize Indigenous peoples' self-governance and proprietary rights over their lands and resources, especially in the context of natural resource development investment activity. Without land and resource tenure security or recognition of their inherent decision-making authority, Indigenous peoples are disadvantaged in their capacity to come to any fair or just agreement with investors or the state as regulators over any resource development in their territories. States, along with others, should also shift from still persistent colonial era attitudes that see Indigenous peoples as incapable of managing their own affairs or taking on sophisticated roles in modern economic spheres. Instead, states should take seriously their international law obligation to fulfill human rights, including the human right of Indigenous peoples to self-determination and develop. And thus, states should support Indigenous peoples that are in the path of proposed investment projects so that they may have the wherewithal to make informed choices. And if the choice is on the consent side of FPIC, that support should go toward enabling Indigenous peoples to have the financial wherewithal to acquire equitable partnership in investment projects, as we see happening to some extent in Canada through government loan arrangements. For their part, investors and companies must take seriously their responsibility to respect human rights, including the collective rights of Indigenous peoples. It is a truism that only by respecting Indigenous peoples' rights can Indigenous peoples have the capacity to genuinely opt for the consent part of FPIC or come to agreements with companies that are respectful of those rights. Finally, mechanisms should be put in place to ensure that Indigenous peoples have or have access to the technical and financial capacity to engage with companies on a level playing field. In many instances, putting those mechanisms in place will call for creative cooperation between Indigenous peoples, states, companies, non-academic or academic institutions, and non-governmental organizations. All too often, NGOs and law school clinics are there to assist Indigenous peoples to withhold consent and oppose projects. And I've done that. The assistance of NGOs and academic institutions should also be available to help Indigenous peoples realize the consent part of FPIC and to do so on a level playing field. So last night at dinner, Guru Rinzal reminded me of the work of Upendra Baxi. Thanks for that, good bad one. Baxi wrote about what he called an emergent trade-related market paradigm of human rights. He characterizes this paradigm as a network conception of trade, investment, and ethical business conduct that can ultimately be conducive to human well-being. Add to that network conception of the conception of self-determination of Indigenous peoples and the human rights of all those who find themselves within the footprint of designs for investment activities. And add to that all of our productive imaginations for not just cabining investment within the limitations of human rights, but also harnessing it to advance human rights. Thank you very much for your attention. I guess we take questions? Okay, yeah. All right, I'm happy to take any questions or comments, criticisms, otherwise. Yes.
Yeah, I just had a question about like just enabling communities, particularly like farmlands still don't have like affordable, reliable broadband internet. So, how do you see that playing a role in enabling people, especially to have a digital infrastructure,
right?
How to communicate their rights?
Right. That's a great point. That in many rural areas in the country, and certainly in areas where indigenous peoples live in this country and many others, access to many essential technology we see essential days, such as broadband internet, is absent. And that would be one of the elements um, that government itself should be targeting in assisting indigenous peoples to realize self-determination. Ideally, indigenous people should be in the position themselves to be able to build that capacity. But many times, as we see across the globe, the situations of disadvantage don't allow for that. So that's where we have the place of international cooperation of different kinds, governments, non-government organizations assisting with that, but with always the end of local community self-determination. Now, I mentioned specifically states and governments because, in fact, states have, as those of us who focus on international human rights law know, states have an obligation to protect human rights and fulfill human rights. And today, that obligation extends to providing communities with the capacity to engage in the world around them and lead fulfilling lives, which today requires that kind of technology. So that's why I particularly emphasize the responsibility of governments because of that legal responsibility, international legal responsibility that states have. And of course, when we're talking about international legal responsibility, many times that's more of an ideal than a reality, but nonetheless, that's what we international human rights law people are here for, right? To always remind states of that international obligation. Anything else? Yes.
Thank you for the presentation. And my question is, as you propose as the indigenous communities to be part of like agents of their own development, agents of their own like companies even, and that states play that important role that like giving them like the tools that they need in terms of technical, financially, etc. But what happens when even the state is not capable of giving that normal citizens, and how that will play a role in given that it's like populations that are only in conditions of vulnerability? Do you think that maybe also these tools can be given by the companies or like in terms of the partnership that you propose?
Generally, yes, at least in theory. It's very touchy, and so the state has a role to ensure that any assistance provided by a company is without the kind of strings that the company might want to have over the community. So it's a difficult thing, but it is at least theoretically possible, and we do find instances where engagements by indigenous peoples with companies does lead to greater capacity in different ways that the indigenous peoples themselves can use in future engagement. The consent agreement that I mentioned in Belize, and there are several other examples of that, include certain seed money for the negotiations themselves. That seed money that was put into a trust so that the company doesn't have control over it, but that the indigenous communities themselves have over to use as they find most useful in their engagements and negotiations with the company. And so you could apply that same model of companies putting money in trust, free of the kind of controls that they might otherwise have, the companies that is, so that indigenous peoples can use those funds for their own ends. Like I said, it's tricky, and I'm not saying it's easy to do. But with all the capital that's flowing in, otherwise, there has to be ways among us, all the bright minds that there are that are doing work in the field, that are engaging with indigenous peoples, assisting them. There has to be ways that we can channel that a slice of that capital at the outset to put indigenous peoples in a place where they really genuinely have choices. I don't have all the answers in that regard. I can make a few observations about where things have worked or not worked so well. But we are talking about, in many cases, a lot of capital going into these investment projects, just in the exploration phase, or even in the phase of studying the factibilidad. What is that? What's the word in English for factibilidad? What's the word? Someone help me. Feasibility. There you go. My main language is English, but sometimes, the Spanish word sticks in my head. Feasibility, even so companies do feasibility studies even before they have guarantees of moving forward with the project, well before. And they spend a lot of money on those. And somehow some of that money should be able to go, if indigenous peoples or other communities are in the physical footprint of their project, should be able to go to assist them to engage effectively with not just the company, but also with the government. So, I leave that to perhaps the younger people in the room to think about how these kind of mechanisms can be devised. Yes, awesome.
Well, thank you so much, Professor Anaya, for everything that you've always done for the human rights field and all of the learning that you continue sharing with us. We're incredibly grateful for that. I wanted to ask a question about the UN Rules Principles, because you mentioned the mixed record of implementation. Do you think that a treaty in this area would make any sort of difference, and how would this impact indigenous peoples if we did have the treaty?
Well, yeah, that's an ongoing debate, right? There is an initiative to develop a treaty on business and human rights through the UN Human Rights Council. This initiative pushed initially by Ecuador. I actually don't have an update on how it's going. Maybe the special rapporteur here does, but we don't have a treaty yet. I do know that. The treaty, however, the way it would work, as I understand it, because governments wouldn't be parties to the treaty. I mean, excuse me, businesses wouldn't be parties to the treaty. It would be states would then make commitments to regulate business. And that would be an important contribution, but it still leaves the question of businesses' exercise of their own responsibility, right? And I think that is a very important tool to be able to press businesses and for businesses to adopt within their policy frameworks this commitment to respect human rights independently of the regulatory apparatus that the states has over them. So yes, it could be useful because presumably a treaty would require states to have due diligence laws to regulate businesses closely over a range of matters relative to human rights, including environmental matters, and that would put countries, that would incentivize countries, presumably, right, to do more of that regulation. But there is still the question of what incentive do businesses have, or what commitment do businesses have, better say, independently of the regulation that is imposed upon them by states to respect human rights. And I do think there's a lot of value in businesses themselves having a culture. I know this word is overused in the business sense, but having a commitment that's filtered throughout business operations from the top down to the operational level, a commitment to human rights, not because they're being told to respect human rights by law or companies, because often the enforcement mechanisms for state regulation is weak, especially in developing countries, or well, in the United States as well. Often that's weak, and so having that independent commitment and also the external pressures directly on business to respect human rights I think is useful. I mentioned, that many companies have in their policies. You can, go online, look at the human rights policy, see a explicit commitment to the UN guiding principles. Associations like ICMM, International Council of Mining and Minerals, has explicitly committed to the UN guiding principles. Now, when I say they've committed, I'm not saying they're complying with it, but even that is a step forward and is a tool for advocates to use in their engagement with governments or in their engagements with companies. And we see companies being the direct object of advocacy more and more. And it's certainly a tool when local communities or indigenous peoples want to engage with companies to have their commitments, particularly their commitments to respect human rights. It's a tremendous tool to use. If the companies are to act at any level of good faith, they have to take seriously that commitment in there. So, I mean, that's a very important question, and it's something it's interesting because if we look at the Inter-American system as opposed to the UN system, the Inter-American system has emphasized much more the obligations that states have to regulate businesses and put much less faith in the idea of independent business responsibility to respect human rights. So there's a lot to be discussed there, and we can go on and on about that. Yeah.
Gina and I thank you for being here. Can you just talk about the extractive industries transparency initiative and how that is helping to advance human rights for indigenous people?
Well, it's one of the many initiatives we see among industry, the Equator Principles, or we could go on about these different initiatives. My problem with a lot of them is that there's so many initiatives that have us in conferences and different ways of looking at moving forward with corporate social responsibility, that often, with all this activity, there's not enough operationalization of the actual standards. And so I would like to see more effort being done to that. For example, when ICMM does commit to the UN guiding principles on business human rights, what does that mean? I mean, do the people, at the operational level of a mining company in Ghana, for example, do they know what that means? Right? The people at the operational level of a major mining project in Arizona, Mexico, my part of the world, do they really know what that means? And I can tell you they don't. And so there needs to be that filtering through to the ground. And I'd like to see many more initiatives devoted to that.
I'm concerned because I think the 135 million that USAID was using to implement the initiative,
right,
is probably gone for now.
Well, that's not a good thing. I'll say that. Yeah. No, I'm not criticizing the initiative. I'm just saying that I would like to see much more put into these, operationalization sort of level. Yes. Go ahead.
Yeah, thanks.
Marcos.
So on the standard of FPIC and its application in practice, so as indigenous peoples are not monolithic, and there may be divisions. Some may be for consent, some may be against. Also to express and pay more attention to the consent point. Would that aggravate those divisions in a way? And if so, how could that situation be addressed?
Yeah, that's a good question. But I mean, yes, it could, but no more than focusing only on the no consent part aggregates divisions. I mean, that causes a lot of divisions, where especially a lot of, just to speak clearly, in my experience, observing things and having experience in different parts of the world, a lot of times the supporters of indigenous peoples who are impoverished in different parts of the world, don't have the policy framing of no extractive industries. We're supporting indigenous peoples basically to oppose mining or extraction. Now, I don't want to say that that's not in good faith, or that in many instances that's not appropriate. It is. There's a lot of horrible extractive activity going on, causing all kinds of very serious human rights problems, as we know, right? But we don't have, like I indicated, a lot of human rights clinics. We don't have a lot of NGOs that are out there. Well, we're going to help you do a really good deal. We're going to explore the options, right? So in either case, indigenous peoples, I think, on the ground, on their own, trying to sort of filter through whatever outside influences might be there, the environmental movements or others that have their own agendas, which I generally share, by the way. But that do influence. If we can sort of put that away, I think what experience shows is that indigenous peoples, like other people, want to live good lives, and they want to have the best for their children and future generations. And many times that will not, in any instances, in any instance would that contemplate an industry on their territory, but in many cases, experience shows it will. I mean, one of my early cases right out of law school was to help the Santa Ana Pueblo, which is the tribe in New Mexico, the Pueblo Indian people, recover land. And so it was my first time to DC, actually coming here to work on the legislation to get that land recovered. And we had litigation as well that pushed that along. But there was all this criticism about that from all kinds of sectors. So that's going to take it out of the public domain. Certain environmentalist groups are afraid of what their tribe was going to do because they were contemplating different kinds of development. Within the tribe itself, there's a lot of debate. What are we going to do with this? How are we going to? Because it was targeted for economic development. That was the argument made here before the congressional delegation. But one of the things they did, among many, was develop this, what I consider to be the highest end luxury resort in New Mexico, which is my home state, in the territory of one of the most traditional indigenous people in the country, if not the world. And these are highly traditional people. And they have a beautiful golf course. And I've been out there a couple of times, and to see how they are in control of this resort, to see how they have done this in a way that is, from what I can see, in harmony with their the natural environment and their way of life. They have, like I said, a beautiful golf course. I'm not a very good golfer, but I tried it. It's very difficult. They have all kinds of turns and traps and all kinds of things. But there are also, throughout this golf course, there are sacred areas. And you'll be on your cart or walking, you'll see, please don't go here. It's off limits. Please don't go here. It's throughout the golf course. And I was just thinking, the first time I tried that golf course was, if this were not indigenous owned and run, what would this golf course look like? People would be trampling over those sacred areas. So it's not that and I know they had a big debate about it, but the debate was resolved in favor of going with this big resort area, but one that in a real sense, I believe, is in harmony with their way of life and with the natural environment as they see it, and that is much more protective of their cultures and ways of life than anything that would have been put in place by someone else would have been. And so, I mean, there's a couple of lessons from that, right? When you see this very highly traditional indigenous people, those of you who've been to the Pueblo people, among the Pueblo peoples or close to them, and will know that they're among the most traditional. They have the Kiva societies, all kinds of things we could talk about. Yet, you can see them increasingly open to certain development, but that because they're in control of it. So that's one thing. It's not like it's necessarily in contradiction, as certain kinds of development. But then the other thing is when they're in control of it, it's going to work much better for them and for the environment and for their values. Yes, there's divisions. There's always divisions. But I would say that both, if they're pushed towards the no side of consent, no consent, that creates divisions I've seen. If they're pushed to consent, that will create debates or divisions even, yeah. The solution is just give them the space so that they can decide. Give them the space so that they can acquire the information necessary, assimilate it in their own ways, in their own languages, literally, and make a decision. So that the free part of consent is not just free no consent, but it's actually free consent. I think we're out of time. Yeah. Okay. Thank you very much.